Hey everyone, I wanted to give you all an update and a recap as to what happened with the Wallace and C-Spine cases that came down through the Supreme Court on July 3rd of 2025. As we've discussed in the past, and I've lectured on this for the past five seminars that I spoke at, Wallace to me was the most consequential and most destructive Court of Appeals case that has come down in terms of no fault cases since Covenant. It has wreaked havoc on many of our practices, causing millions and millions of dollars of bills to be dismissed. In the past, I've talked about why assignments should not be utilized anymore in light of Wallace. I want to kind of touch on sort of the background as to how we got here, and then what the Supreme Court finally said about Wallace. First, I want to acknowledge Matt Payne, who was the architect of both the brief and also argued Wallace and C-Spine in the Supreme Court. He did a phenomenal job. I attended and helped him with a mock argument with the amicus committee, and all along I knew that he was going to be successful in getting Wallace overturned, and both C-Spine and Wallace overturned, and he did just that. So I want to give a big shout out to Matt Payne and thank you for all the work that you did, Matt. Now, the C-Spine case is just as important from a case law perspective and its impact on the No Fault Act, but it does not touch as much of our day-to-day practice as Wallace does. The C-Spine case is mostly having to do with medical providers and provider cases, specifically for those medical providers who have sold their account receivables to factoring or funding companies. That is essentially what C-Spine was, and so it does not affect as many of the MAJ's general practices and firms as the Wallace case does. So I'm not going to discuss the C-Spine holding as much, but you should read it when you get a chance. What I want to focus on is Wallace. So let's start out with how we got into this position in the first place. We got into this situation with Wallace because back in 2017, the Covenant case came down. And if you all remember, Covenant basically took away the independent right for a medical provider to file suit. So standing was removed from a medical provider to file a direct action against the no-fault insurer, and that standing had been presumed for many years after the Lakeland NeuroCare Center's case from 2002. So from 2002 until 2017, we had been operating with the assumption that medical providers have standing and the right to pursue their own action to collect their medical bills against no-fault insurers. The Covenant case came down and said, no, you don't have an independent right of action. And so medical providers started scrambling because they had a lot of bills that were already in suit that were getting dismissed. Every single day, thousands and thousands of dollars of bills were getting dismissed in courts because of Covenant. And the recourse that we collectively came up with as no fault and PIP attorneys was that we needed to get assignments to preserve the medical provider's rights when they were already in suit or if they wanted to file suit going forward. So that is what we started telling medical providers to do. If you want to file a lawsuit on your own behalf, if you want to collect the bills yourself and not have to rely on the patient's attorney, then you should be getting an assignment. And so we started telling our provider clients that this is what you need to do and this is how you need to address these situations. And so the sophisticated medical providers started getting these assignments, and they started going through business as usual, filing in the circuit courts and filing in the district courts. And they also started telling their colleagues and their trade associations and all of the referral partners that, hey, if you want to protect yourself, you need to get assignments. And we collectively as attorneys were telling medical providers, if you want to protect yourself based off this Covenant decision, you should be getting assignments. And so a lot of these doctors and therapists and imaging centers and medical providers were getting assignments blindly without really understanding why they were doing it. A lot of them didn't have access to an attorney. A lot of them did not do a lot of no fault work, but were just getting these assignments because they believed it was in their best interest and it protected them legally, without actually understanding what it protected or why they were doing this. And so these assignments were being were included as part of the discharge procedures for most of these providers, and all was fine until the unpublished case of Macosta versus Metropolitan Group came down in 2020. What had happened was that the insurance company had already paid Macosta's bill to the plaintiff's attorney. The plaintiff's attorney included in their lawsuit. But then Macosta came around and said, we are also claiming that same bill. And the insurance company ended up having to double pay in that case. And that was what ultimately set off this chain of events where insurance companies started saying, we need to get revocations of your assignments. We need to ensure that we know the exact party that is entitled to the reimbursement from the no-fault policy. We need to know the real party in interest. And that is why they started requesting these revocations. They started saying, hey, either we pay the patient's attorney or we pay the provider's attorney. We pay either the patient or the provider for a specific medical bill, but we're not doing both. And the way we can be sure that the patient's attorney, the plaintiff, injured claimant can claim this bill is by showing us that you have a revocation of the assignment from the provider. So that was sort of the state of affairs for a few years from 2020 until 2023. And so for 3 years, that was the protocol, is that if you have an assignment, you can remedy the double payment issue by revoking the assignment, and that way the insurance company knows that it is the patient's attorney and the injured claimant that should be getting payment for a certain bill and not the actual provider. So what the Wallace holding in the Court of Appeals ultimately ruled was that a provider needed to either file its own lawsuit within a year of the service, or it had to revoke its assignment within a year of that service. That ultimately caused a lot of issues in our PIP cases because many providers had relationships with plaintiff attorneys and attorneys for the injured claimants, and they wanted to include their bills with the patient suit. But they also had an assignment as a matter of course because that's just how they have been practicing for the past, decade or so since Covenant. They've been trying to protect themselves, and so they had all these assignments that were way older than a year, and there was nothing they could do about it. So the insurance companies basically went through and started sweeping all of these bills, saying, hey, you did not revoke your assignment or file suit within a year, and so we can dismiss these cases. And I'm sure many of you have seen this. The courts were regularly just sweeping cases because there was no revocation or filing within a year, and PIP cases were essentially erased entirely because of this Wallace case. So this ultimately went up to the Supreme Court, and in the Supreme Court, they ultimately reversed the Court of Appeals, but it wasn't a very forceful reversal, but it was a reversal that we can work with. So here's essentially what the Supreme Court said. The Supreme Court made the distinction between a revocation and rescission. Court of Appeals looked at what happened in Wallace as a revocation, even though they called it a mutual rescission. And the Supreme Court wanted us to be aware that these are entirely different terms and they cannot be used interchangeably. A revocation basically gives the rights back to the assigning party. So the injured claimant would get the right to claim the bill back if they revoke the bill, but it's not as if the contract was never in place in the first place, which is a rescission ad initio. What the Court of Appeals said is if there is a rescission, the contract is entirely taken away as if it never existed, and therefore the courts would have to first weigh if that is allowed, They have to weigh the equities to see if rescission can and should be done, and whether or not the 1 year back should be applied here, because essentially that contract never existed. So they've always, the initial complaint technically should be timely, because there never would have been a 1 year back rule if the assignment never existed. So what the Wallace court is ultimately saying is that if the courts weigh the equities and grant rescission, they are implying that the 1 year back rule should no longer apply, because the injured claimant would have had all of the bills in the lawsuit from the beginning, because that assignment never existed. And that is a huge win for us. I don't know if I did a great job explaining this. I know this just came out and I just read it like a couple hours ago, but essentially this is a huge win for plaintiffs and helps us with the assignment issues we've been facing significantly. And so again, I thank Matt Payne for all the work he did. For those of you who have current cases, you should be filing motions to amend. There's a plan provided within the opinion itself. File motions to amend to substitute in the correct real party in interest. File motions to intervene, allowing the real party in interest to intervene under 2.209, and filing an amended complaint reflecting a new assignment. This is a roadmap that was provided by the Supreme Court to get around the assignment and 1 year back issues. So hopefully this clarifies a lot going forward. And if you have any questions, feel free to shoot me an email and we can talk more about it. Thank you.